The digital age has not only revolutionized how we communicate and do business, but it's also reshaping the legal landscape. When it comes to wills, we're seeing a new layer of complexity emerge as people get creative with technology. In Australia, we've already had cases where the courts have had to grapple with the question of whether video wills are valid.
Can you explain to me what exactly a video will is and why so many people out there are actually considering it as their will or their format for their will?
So in this digital age where everything's moving to social media, photos and videos, it's understandable that video wills are becoming more common and popular as well. So video will is, based on my understanding, when a person wishes to document wishes in relation to their will and estate planning over this forum, like a video.
So we're obviously now trying to establish whether a video will is valid in the eyes of the law. So before we get into that discussion, could you just clarify what the legal requirements are for a valid will in New South Wales?
Section 6 of the Succession Act requires a will to be in writing, will to be signed by the testator or someone at the direction of the testator, and to be witnessed by 2 adults.
You've mentioned the formal requirements of a will, and obviously a video will does not meet any of those requirements. So my question, I guess, is, does the court actually have then the power to still say or rule that a video will is actually valid and then have an estate be distributed according to that?
Very good question, Taylor. So the court has a general power to overcome the formal requirements of a will. So they may, in exceptional circumstances, come to the decision that a video will does reflect certain intentions of the testator, and then that video will can be treated as an informal will.
Can you discuss some of the challenges that a court might face in validating a video will?
There are a lot of challenges that a court may face in validating a video will. For example, the time and date that video will was made, whether the testator had capacity at the time of making it, whether the testator was coerced or was under any duress when they made it. And in the absence of witnesses, it's very difficult for a court to work out whether that video accurately reflects the last wishes of the deceased.
Do you think a video will then can override a written will? And then I guess maybe just elaborate also on if there is if the person has a video will and a written will and there's contradiction between the two of them, and which one will take precedence?
So I think the short answer is a video will not override a written will, and where there are inconsistencies, the written will apply. But I guess just to add a bit more clarity to that answer, I do really understand why people may want to make a video will. It's an opportunity to use a forum like this to really talk to your relatives and your loved ones. It's an opportunity to maybe explain why you've left certain assets this way, that you've intended certain distributions to be made in a specific way. But what's important to understand is that currently in New South Wales and in Australia, video will is not valid. At best, it's recognized as an informal will. And so really what it does is it adds complexity to an otherwise complex situation, and will add additional legal costs to go to a court to prove or to try to substantiate this video will. And all of those costs will need to come out of the estate. And so that's going to reduce the amount in your estate for your remaining beneficiary.
So for those who are thinking about a video will, what are the potential risks and challenges associated with this format?
So something I've just learned just recently is that the impact of AI and the ability of AI to use someone else's photo and then to superimpose that on your face while you're creating a video, which will apparently, what I've been told, is very realistic and will use your facial expressions, etc. So if you think about that and we use that technology, then what's stopping someone from impersonating me in the making of a will, especially where there are no lawyers present and there are no witnesses present?
I guess, and then how can these risks be mitigated?
So the easiest way to mitigate this is to actually use the tried and tested mechanism way, which is to write a will, have a written will, which is then witnessed by 2 adults. If anyone has any questions or doubts, you always speak with a lawyer, because the lawyer will be able to answer those questions, right, and explain to you why a do-it-yourself will kit isn't good enough, explain to you why or the dangers and costs of doing a video will, which is the main issue is that your wishes will not be reflected.